And another.
My Lords.
Ms Stevens-Hall.
Good morning. I appear for the appellant in this matter, accompanied by my learned friends Cameron Stocks and Oliver Ingham. The respondent is represented by Constance MacDonald, who's in the middle, Christopher Wagstaff, sorry, I should have said Constance MacDonald, KC, Christopher Wagstaff, KC, and Sophia Rogers on the far end. And can I say, on behalf of my learned friend, Mr MacDonald, and myself, thank you very much for agreeing to sit a bit early and a bit late.
Not at all. We'll take a break at some convenient point mid-morning. And
we've agreed a target
and
time.
again in the afternoon. And if anybody needs a break at any point, then do say.
I'm very grateful, my Lord. My Lords, if I can just first of all give you a sense of the structure I'm going to adopt. I appreciate it may well be that you want me to approach matters in another way, and I'm happy to be flexible. I'm going to deal as quickly as I can with a few introductory points. Language that I will be using to distinguish various things because there are a lot of overlaps. A couple of corrections in our written statement. And then in a nutshell, what we're saying and what we're not saying, to clarify. And then, from my submissions primarily, I will break those down into statutory interpretation and Section 86A6, then the Inheritance Act generally and maintenance specifically, and then the CPR incompatibilities and barriers as we put them. Then at the end, I will deal with where we say both the judge at first instance and the Court of Appeal went wrong.
Thank you.
So, to language, my Lords. You'll note from both parties' written statements that written cases that the outcome from Inheritance Act proceedings are described as an award. And I know some of your lordships certainly are very familiar with the Inheritance Act, indeed, three of you having had to consider it in the summer of last year, I think, and the comparisons with the Matrimonial Causes Act. I will adopt the expression award to refer to what comes out of the Inheritance Act, but make the point that when you look at Section 2, what is being made is an order. Section 2, in fact, the Inheritance Act as a whole, doesn't use the language of award. I'm going to use it because it is helpful in this context. One, it's how we tend to talk about it, but it's helpful in this context to talk about when I'm addressing an order that's made under the Inheritance Act and when I'm addressing a different order that's made under a different power. I hope that makes sense. Then another area that we have with overlaps and distinctions, and so language needs to be clear, is for the purposes of the Inheritance Act, maintenance-based awards and what I will call spousal awards, i.e. the awards where the maintenance requirement as part of reasonable financial provision does not exist. So far as Matrimonial Causes Act is concerned, as you may appreciate from prior knowledge or have picked up if you have looked at the Azami case, under the Matrimonial Causes Act, you can have needs-based awards or sharing awards. And when I use needs-based, that will be a reference to the Matrimonial Causes Act rather than the Inheritance Act. And I say that because there is, we say, structurally a difference between the two, in that you don't go straight from needs to an award in the Inheritance Act. You have to go through the reasonable financial provision and for everyone except spouses, the maintenance requirement. So maintenance-based Inheritance Act, spousal award Inheritance Act, distinguishing the two. Matrimonial Causes Act need-based. I doubt we'll get into sharing-based, where non-matrimonial property is more relevant and respected, but if we do, I'll use that language. In terms of corrections, in our written case, in core bundle page 125, I should have asked your lordship, so are you happiest if as far as possible I stay in core bundle?
Well, we're all working off, we'll have a hard copy of the core bundle, but we're all working off electronic documents otherwise.
Okay.
Now, I don't know whether the respondents are working from hard copies or from electronic bundles.
A bit of both.
A bit of both, so we'll have to ask you to do both then, please.
The references should be the same.
Thank you. But we have hard copies of the core bundle, everything else is electronic.
Thank you.
So we're going to the core bundle at page
125. I'm just having a nasty sneaking suspicion that by that, therefore, by core bundle, you're referring to what I've called key documents bundle. So I will segue to page 48.
Perhaps paragraph number would be helpful.
23.
paragraph 48 of the written case, paragraph 123. Thank you.
Sorry, it's just over the page.
This is your written case?
This is our written case.
Yes.
There is a missing word in paragraph 123. Between no and detailed, it should say no more detailed. I apologise for that.
Thank you.
And over the page at page 100, paragraph 129.
I don't see what the more adds, actually. Doesn't make any difference. If we're going to spend time on typos, it just means exactly the same. If anything, it makes it a bit less grammatical.
It's following on from the previous paragraph, which referred to some information that came.
Oh, I
the point
see.
is nothing compared to that, so I hope that helps, my lord.
Yeah.
And the other correction?
Is at paragraph 141, which is on page 52. This one is more fundamental. In the second line, the figure 84,000 odd that's gone in is an error. That's the base cost figure, which you may have seen referred to elsewhere. Apologies for that. It should be 48,175.
Thank you.
My lords, in a nutshell, we say there are two primary points in this matter. Whether there is a statutory bar coming from section 58(6)(a),
58A6.
I've been doing this for the last 2 weeks, my lord. I will really try get it in my head. I thought I'd got it there. I have to warn you, I did once call a success fee a sex fee as well. I will also try not to do that. I've probably guaranteed I'm going to now by referring to it. Section 58A6. As a statutory bar, we say it is a bar. It's a bar that prevents any order that deals with costs, whether that is to order payment, to provide that someone's not going to recover them, whether it deals with costs along with other things, costs and interest, or as in this case, costs and other said to be reasonable financial provision under Section 2 of the Inheritance Act. So that's our ground one, which I think, in fact, you'll only find in what I've got called the core bundle, but I'm wondering what you have it as.
Key documents.
Which is the bundle that has notice
The
of...
core bundle starts with the statement of facts and issues, has the written
Yes.
cases and the judgments below.
Yes. What other bundles do your lordships have?
Well, we have a large number of other bundles.
I'm
but
sorry about that.
we have
You have one that has a number of documents in the case, and then including the appendage of essential documents, and then the legislation, cases and text, and then one that's purely...
Yeah, no, you're quite right.
Sorry.
That is the core volume. This is the key documents bundle.
this is the key document.
Yeah.
Sorry,
Right.
it's my fault.
Yeah. So when you refer to core volume or core bundle, we've got that electronically.
I'm grateful. And are you all able to and happy to use that? I'll
Yes.
endeavour to give the other
We have it in an
references.
updated version, which was logged on the 11th of January.
That's an updated version. You may have the two knitted together, but of a bundle that's just authorities.
No, the core volume includes the notice
We've
of
got
appeal, the written
updated versions of
cases,
both
and then
bundles, yeah.
authorities. Yeah.
I've lost track of the bundles, I'm afraid. We disappeared so far into them, and I do apologise, my lords, if...
Anyway, there's a lot more stuff in them than's relevant in this case, as far as I can see.
So I am primarily going to work from what Lord Burrows identified as the core bundle, or whatever other words are best used. So in that bundle, the statutory bar is our ground 1, which is at page 35, or in the issues, in the statement of fact, which is page 84. It's paragraphs 23 and 26. The second key question is the court entitled to make a maintenance-based order on the basis it provides, wholly or in part, for the payment of a success fee? I.e., if an order is made or purports to be made using Section 2 of the Inheritance Act alone, we say no, because it would not be addressing reasonable financial provision that the estate, through the will or intestacy, had failed to provide. That would apply across the board so far as Inheritance Act claims are concerned. And secondly, no, because it's not full maintenance, and that would only affect non-spousal claims. That's ground 3 at core bundle 30, page 36, and the issue in paragraph 22 at page 84.
I'm sorry, I've got slightly lost.
Yes.
I think you started by saying there were 2 preliminary points.
2 preliminary
But you
points.
then referred to a third ground of appeal.
I gave the answers.
Can we just... I just need to get this clear.
Absolutely.
So the first point you raised was whether there was a statutory bar under Section 58A6, as I understand it.
Yes, whether
What is it?
Section 58A6
Yes.
applies so as to bar
Yes.
an order that's being made by the court under the Inheritance Act.
And that turns, as I understand it, on what
the
is meant
statute.
by a costs order. Is that
We
right?
say yes, and we say that.
And that's raised at paragraphs 23 and 26 of the Statement
Indeed.
of Facts and Issues.
Yes.
Okay. What was the next point you made?
Is the court entitled to make a maintenance-based award under the Inheritance Act on the basis it is providing for the payment of a success fee?
Yeah.
And we say the court is not entitled to do that because the payment of a success fee cannot be, we say, reasonable financial provision across the board. And even if we're wrong about that, it cannot be reasonable financial provision for maintenance, although if it were only that point we succeeded on and none of the others, then that would only apply, it seems to us, in a case like this, which is a maintenance-based award, a non-spousal award.
But do you accept that it's a debt?
Accept it's a debt.
Do you accept it's an obligation?
Accept it's an obligation. So it is part of the factual inquiry under Section 3 of the Inheritance Act, to which, my Lord, I think you're referring. But we say that factual inquiry has to then inform a conclusion by the court as to whether there's been a failure to make reasonable financial provision, and then the exercise, not necessarily as two separate processes, it can be together, but having identified if there's a failure to make reasonable financial provision, the court then gets to its discretion about whether to provide, to redress, to make good that failure to provide reasonable financial provision. So there's a question beyond pure need as to whether it qualifies as a failure to make reasonable financial provision in order for the court to have the discretion to make it. And in non-spousal claims, that has to be reasonable financial provision for maintenance. So there's an extra step.
Exactly the same words are used in the Matrimonial Causes Act.
We do not see in the Matrimonial Causes Act reasonable financial provision, the failure to make reasonable financial provision from a will or an intestacy, or indeed a constraining of the making good of provision, financial provision, by the need for maintenance.
But that can't be what drives the difference between the two approaches, can it? I mean, it all must turn on how costs work in the two different regimes.
That is, my Lord, you're right. We have the other grounds that relate to the incompatibility with the CPR. The position is that inheritance acts are squarely placed within the CPR by CPR 57. And we would say that Mr. Justice Briggs, as he then was, in Lillyman, was right in coming to his conclusion that he could not, and it wasn't fully thought out, both counsel urged it upon him, he could not sidestep the judicial exercise of discretion that the CPR calls for. And that, we say, is a consequence of the respondent's approach that when you start working it through, leads to a huge number of problems, because although legally the case is under the CPR, what the respondents are inviting you to do is to treat it procedurally and for the purposes of the cost regime as under a completely different regime where CFAs don't exist, where there cannot be without prejudice offers, there is no Part 36, and the court has evidence in front of it in order to consider how to deal with costs at the point of dealing with every other aspect of the relief. So I think that's...
So although the base costs are not an issue here, they could be in another case.
My understanding
and one thing that we might want to address is possibly whether, I think respondent argues in principle, they could be included in the award.
My
and
understanding...
presumably you would argue not.
My Lord, exactly. My understanding is from the respondent's statement of case that they do say, indeed, that the
they say the judge has a choice, I think, as to whether to include them in the award or in the separate costs order.
And put simply, my Lord, we would say that even if, contrary to our primary position, the court has a discretion under the Inheritance Act to bring these costs into the order that is an award. That does not oust the constraints on the discretion the court has when it is dealing with costs, insofar as the subject matter is costs. And we say it's square.
That's a rather convoluted way to put it, but I think what you're saying is, in principle, the court has a general discretion, but because there's a separate cost regime, it ought not to exercise it in the area of costs, because that's covered by a different regime, which won't work if you start making orders for costs as part of the award.
My Lord, we say in principle it doesn't have a discretion, and...
But that's your argument based on construction, is it?
Based on construction and based on the operation of the Inheritance Act, and whether something such as a success fee, which is related purely to funding the costs of the litigation, so was not, and so far as reasonable financial provision is concerned, we fully accept that the court has to evaluate that at the date of the trial. But it is still engaged, as is clear in ILOT, and I'll take you to in a moment, it's still engaged in a process of saying, from the position of the deceased, taking all the factors in account, was there a failure to make reasonable provision? And then exercising the discretion to use the powers under Section 2, should I make reasonable provision to fill that gap? So we have the question, a person may have all sorts of needs, but do those needs actually fall into the basket that is properly described as reasonable financial provision? We would say it can't, because it is not something that can, from the position of the deceased, be something they could or would have made provision for, even at the date of trial. Because what it is the cost of litigating to get the reasonable financial provision.
So suppose the cost rules were changed and this regime, inheritance regime, were made subject to the family proceedings rules and the costs provisions that come along with those, that you start with a presumption of each side bearing their own costs and offers are open and so forth, and there's no Part 36 offers. Would you still say that costs would have to be ignored under the Inheritance Act, although they can be taken into account under the Matrimonial Causes Act?
We would say you'd have to do more than simply say the family procedural rules apply. You would have to address the fact that needs does not of itself equate to reasonable financial provision or reasonable financial provision for maintenance. Now, that's not to say that Parliament couldn't do it, or secondary legislation might even be able to do it. I'm not a parliamentarian, so I'll bow to those who know much better, including some in this room. But you'd have to do more than just change the procedural rules.
Well, I would be assisted by looking at the actual legislative provisions.
Certainly.
Well, you're making it what seems to me a conceptual point about the operation of the 1975 Act. Because, I mean, the point put against you, as I understand it, is that debts can count because if you've got to meet a debt, that's going to have an effect on the rest of the assets that are available for your needs, and therefore, so long as you could causally link, there is no conceptual reason why any debt, including a debt to pay litigation costs, could not be included. But you're saying...
We say that's wrong.
You're saying that's wrong.
Debts can be, but not every debt. So not every need, not every debt. There has to be a quality to it that means reasonable financial provision. And so far as non-spousal claims, maintenance-based claims, it has to be for maintenance. And we have...
You're going to show us then where...
Yes. So shall I take you to the Inheritance Act authorities first? So if I can take you to ILOT, which starts in the core bundle at...
Are you going to the statutory provisions?
Oh, sorry.
I think that's what
Yeah.
my lord referred to.
Indeed, you did. That's absolutely correct.
Good place to begin.
It is.
And end.
So if we go in the core bundle to page 466, section 1 of the Inheritance Act, subsection 1, it first describes the various people who qualify and then provides that a person can apply on the ground that the disposition, whether affected by the deceased will or the law relating to intestacy, is not such as to make reasonable provision for the applicant.
Well, if you have a whole lot of debts and you have to take them into account as to what's reasonable financial provision. I don't see the difference at the moment between a debt in relation to litigation costs and other debts. Where do we get that?
Well,
It's a matter of timing, is it? Is that what you're saying?
there's an element.
What is the time at which you make the assessment?
You make it at the date of the hearing.
Right.
The assessment is that you're making is whether the will or the estate under intestacy has made reasonable provision. The will, the estate, be it under a will or intestacy, could never have included,
Yes.
and at the point where the disposition is happening, would not include litigation about the estate.
But is that generally true, that you can't take into account debts that have arisen after the death of the person in question?
You can take account of, so it's not purely a timing, it's more about the nature of the thing. So because you do the exercise of assessing it at trial, you can take account of things that happen after death.
Right.
But
Why not the fact that
exercise you're
litigation?
doing is looking at the position with the estate and the disposition of the estate. And we say that pursuing a claim for reasonable financial provision is not something that could ever, from the position of the deceased, be said to be a failure by the deceased to make reasonable provision. The deceased is not going to make reasonable provision for someone to litigate at some future point after their death on the basis they failed to provide for them.
Well, you could also say that about other debts, that a testator is never going to provide for someone who makes bad investments and loses money, and
Indeed.
therefore is in poverty and has to look after children, for instance.
Or I suppose the case of someone who suffers a major accident or injury after death and therefore has at that point.
But that's purely a time thing. Because
right.
had it happened before the death, then a testator would. Might be said that they, making reasonable provision, would have or should have.
Isn't this objective? The test is objective, isn't it?
It is objective.
Yeah. So one leaves out of account any criticisms or
Yes.
subjective views or whatever.
That comes in for the discretion stage in terms of the extent to which you, as it were, make good the failure to make reasonable provision. But we say conceptually, this isn't about just time. It is creating the notion that a deceased would make provision for something that is the pursuit of their failure after the event, rather than something where you're just moving the timeline. So conceptually, that's very different.
You're sort of saying there would be an inherent contradiction
Indeed.
if you allowed that sort of debt, because we're actually trying to deal with what will be a reasonable provision, and that by definition can't include litigation about the will.
That question, yes.
I don't
Thank
see
you,
why
my Lord. You put it more succinctly than I
I mean,
did.
suppose you've incurred liability because there wasn't reasonable provision made for you. You've had to pay an exorbitant rent or rent that you wouldn't otherwise have incurred. And so why that shouldn't be included. There can be knock-on consequences of a failure to make provision for somebody in their will.
There can.
And in principle, those can be included, can't they? And one of them,
My Lord,
on that, if you just ignore all other factors, one of them could be the fact that you've had to litigate as a result of the failure to provide you with adequate provision.
Indeed, if you make absolutely no financial provision at all, and there's the most deserving case in the world, then you are compelled to litigate about it, and that would be a lack of reasonable financial provision to enable you to do so.
My Lord, I hear my point is not getting much traction. However, perhaps if I can take you in the authorities to deal with the 3 levels, how you approach that question of what is reasonable financial provision, and it is, we say, from the position of the deceased, and there is the inherent contradiction that was articulated far better by my Lord Burrows than me. Then what sort of debts, particularly in the case we have here, a maintenance-based situation, can actually properly form part again of that reasonable financial provision for maintenance, because it is not everything.
I'm terribly sorry, but I would... You draw a distinction between the 1975 Act and the 1973 Act. Would it be convenient to see what the contrasting provision is? Just while it's fresh on our minds. I'm sorry
if I can
about that.
just then finish with the 1975 Act, and then I'll deal with the Matrimonial Causes Act, and then come to the authorities. Sorry, my lords. We were in section 1. It's section 1(2)(b). So the previous sections have dealt with spousal claims, whether spouse or as a result of marriage or civil partnership. And in all other claims,
this is the definition of reasonable financial provision.
Sorry. Definition of reasonable financial provision in all other claims means financial provision as would be reasonable in all the circumstances for the applicant to receive for maintenance. So there is that extra constraint there. When we go to the Matrimonial Causes Act, sorry, I should also mention, of course, in the Inheritance Act, Section 2 has the powers, and Section 3, which does have a correlation with the Matrimonial Causes Act, sets out the factors. And that's where we get the expression financial need. So in working out what is... Section 3 is on page 472, subsection 3, subsection 1. And making an order and determining whether the dispositions of the deceased estate affected by the will and intestacy, or the combination of will and law, make reasonable financial provision. If the court considers that reasonable financial provision has not made, also for determining whether and in what manner it should exercise its powers, and then the court is required to have regard to a number of things, which includes financial needs, resources, etc. of the applicant. So it's having regard. It's not needs equals reasonable financial provision or the failure to provide it. It's something the court must consider.
Well,
So
the
that's why
person's
we
financial
say-
resources are obviously affected by whether they're going to have to pay a lot to their lawyers.
They are, but that doesn't mean they're a failure to provide reasonable provision by the estate. For the conceptual reason we say, as well as all the other factors that the court takes into account, which would be on the others would be on a case-by-case basis. So far as the Matrimonial Causes Act is concerned, we have at page 498 the equivalent in terms of factors. So it's section 35, subsection 2. Subsection 1, it should be the duty of the court in deciding whether to exercise its powers under sections 23, 24, etc. And if so, in what manner, and to have regard to all the circumstances of the case as priority for welfare of children, and then as regards the exercise of powers under section 23, 24 and 25 with various, 24, various iterations of that, we have a list of factors. So we go straight from the court's power to make certain orders to the factors. We do not pass through the idea or an equivalent idea of reasonable financial provision or maintenance. And if it's helpful, I can take you to the orders the sections that create powers. For instance, we have 495, this section 24. So the various sections 23 and 24 equate to section 2 in the Inheritance Act, but there we see this gateway, this qualification that you have to be able to categorise, or as I've said, put in the basket of reasonable financial provision, the factors you're looking at. There's no question under the Matrimonial Causes Act of a failure to make reasonable financial provision or any equivalent. It's simply a question of the court has a power, it must take account of these things when exercising its power. So you do move straight from factual finding of needs to discretion.
I would have thought that if you ignore the particular factors based on the cost regime and the rules about success fees and so on, it'd be perfectly straightforward to say that somebody who makes no provision at all for an impoverished child, it'd be entirely foreseeable that they need to incur costs of litigation if the estate wasn't going to pay them, and that those costs would come into the mix under the very broad description of assessing the financial resources of the person when you came to decide what redress was required. It's just the plain application of the Act.
I can simply make the point again that in order to apply the Act, you have to go through a step which in maintenance-based claims has two parts between the need and deciding that you're in a position to make an award and what, as it were, the award is being judged against in order to redress the failure to make reasonable financial provision. If you'll forgive me, I'll take you to ILOT in this court, which is in the bundle, starting at page 730. Do you want me to refer to citations, or can we?
Just page numbers are fine for me.
That's fine.
If we can move to page 750. The bottom, paragraph 16, reasonable financial provision. The condition for making an order under the Act is that the will or the intestacy regime does not make reasonable financial provision. Then towards the end of that paragraph, these are words: an objective standard of financial provision to be determined by the court. The Act does not say the court may make an order when it judges that the deceased acted unreasonably. That too would be an objective judgment, but it's not what's required by the court, by the Act. And then at the bottom of that page, paragraph 18, the right test is well set out by Oliver J. in re Coventry. Moving on to the quote. It is not the purpose of the Act to provide legacies or rewards for meritorious conduct. And a little further on at H, in order to enable the court to interfere with and reform the dispositions, it must, in my judgment, be shown not that the deceased acted unreasonably, but looked at objectively, his disposition or lack of a disposition produces an unreasonable result in that it does not make any or any greater provision for the applicant. And that means, in this case, the applicant other than a spouse for the applicant's maintenance. It's clearly not enough to say that that the circumstances are such that if the deceased had made a particular provision for the applicant, it would not have been an unreasonable thing for him to do, and therefore ought to be done now. The court has no carte blanche to reform the deceased's dispositions or those which statute makes of his estate to accord with what the court itself might have thought was sensible if it had been in the deceased's position. And paragraph 19 then goes on to deal with the additional limit for non-spousal cases that comes from maintenance. It will largely turn on the asserted needs of the claimant. It's important to put the matters in the correct place. And skipping the next sentence, for all claimants, for maintenance rather than anything else, and judged not by subsistence levels, it is necessary but not a sufficient condition for an order. Need plus the relevant relationship is not always enough. In re Coventry, the passage cited above was followed almost immediately by another much cited observation of Mr. Justice Oliver. It cannot be enough to say, here's the son of the deceased, he's in necessitous circumstances, there is a property of the deceased that could be made available to assist him, but which is not available if the deceased dispositions stand. Therefore, those dispositions do not make reasonable provision. There must, it seems to me, be established some sort of moral claim Now, the court is very clear it doesn't have to be a moral claim, but there has to be something more than just need and available resources in the estate.
I can see your point that if the court concludes that ignoring the litigation costs, reasonable financial provision has been made, then it wouldn't be right to say that, well, actually, it hasn't because there's been litigation unmeritorious, which has now put the claimant into a position of poverty. But it doesn't follow that the other way round is true. If the court decides that no reasonable financial provision was made and litigation has been brought, then surely in principle what's needed to redress the position, it will include the liabilities that have been incurred as a result of the litigation.
My Lord, we say not.
You're going to come on to your arguments why not, because of success fees and because of the cost regime. But I can't see why, just looked at purely as liabilities without those special factors, there's anything in the Act which would exclude them.
Well, my Lord, we would say if, as it were, going into the question, and perhaps I can take you towards the end of paragraph 23, which is on page 753, where Lord Hughes sums up the position starting at E, and ends with, thus the two questions will usually become, did the will intestacy make reasonable provision for the claimant? We would say when you're asking that question, you cannot be asking that question by reference to litigation to show it wasn't, that it was a failure. And two, if not, what reasonable financial provision ought now to be made? And we say that's the same reasonable financial provision. The purpose of the Act is for the court to have a discretion as far as it considers appropriate to redress that failure.
But the question, did the will make reasonable provision for the claimant, suggests, though I don't think this is what Lord Hughes is meaning, that you look at it at the time the will was made. But you don't. You look at it at the time of the trial.
You look at the applicant's position and the beneficiary's positions at the time of trial.
Yes, you're looking at the financial needs and resources at the time of trial and then saying, has reasonable provision been made?
Yes.
Yes.
If you go back to the test in Ray Coventry, and take the example that my Lord Legate raised of an impoverished child who is being totally cut out of a will and has financial needs, would it be both sensible, which is the wrong test, but also objectively reasonable that the disposition allows the matter to be litigated?
Conceptually, I think I've made the point in various ways. Our submission is it can't be said to be a failure by the deceased to put in the costs of a dispute that may or may not, from the deceased's will, ever happen.
I see that, but this language of a failure of the testator, that's not the point, is it? It's not a failure.
No, it's a failure of provision.
Exactly. It's the disposition of the estate, whether under the will or under the laws of intestacy or under a combination of the two. Looking at the facts at the date of trial, has reasonable provision been made in the disposition of the estate? And that's the only question.
I can see your point. You can't bootstrap yourself into a position of need by bringing an unreasonable claim and therefore saying that I'm now in need because I spent all the money on litigation. But it doesn't follow from that if you bring a meritorious claim, it couldn't be taken into account in assessing what provision needs to be made for you, that you're now impoverished as a result of having to bring it.
Well, my lords, I've said it various ways.
Yeah.
I'm clear as to your lordship's views.
But this is
you're
looking at it divorced from the costs regime. That's the point. You're looking at this. This submission leaves out of account the fact that this Act was enacted against a background that costs were dealt with under the cost
Yes,
regime.
indeed. And what we have, as exemplified by this case, is because there is a problem with the cost regime, the respondent and some others have sought to then plug that gap by jumping across into this regime. And
Now you're
it's
coming
very
to the
telling
point,
that
as I see it.
So
Can I just
you're
deal
moving
very
on from
quickly
ground
with
floor.
maintenance? Can I deal very quickly with maintenance and debts? Because we say not all debts can possibly be reasonable financial provision for maintenance. It's suggested by the respondents that basically if a debt means you have less money to pay your living expenses, that's enough. We say that's a misreading of the authorities, which are approved in ILOC, but I'll take you, if I can, to read Dennis, which starts on page 858. Now, this involved a claim by a child, so it's a maintenance-based claim where there had been a legacy, and the claim was for a tax that would be payable, or was payable, as a result of that legacy. And Mr. Justice Brown-Wilkinson dealt with debts and maintenance, and it's been constantly approved, including in ILOS in this court, page 863. It's now clearly established that others than the spouse are limited by maintenance, show that the will fails to make provision for his maintenance.
Sorry, where
You're
are you
reading?
reading?
Which
Sorry, from just below G. He continues a few lines down, referring to Christie, in which the judge treated maintenance as being equivalent for providing for the well-being and benefit of the applicant. The word maintenance is not as wide as that. The court has up to now declined to define the exact meaning, and I'm certainly not going to depart from that approach, but in my judgment, the word maintenance connotes only payments which directly or indirectly enable the applicant in the future to discharge the cost of his daily living at whatever standard is appropriate. The provision that is to be made is to meet recurring expenses, being expenses of living of an income nature. That doesn't mean the provision has to be by way of income, but it's to be, from his previous sentence, meeting an expense of an income nature. The provision can be by way of a lump sum, for example, to buy a house in which the applicant can be housed, thereby relieving him pro tanto of income expenditure. Nor am I suggesting, and there's a lovely double negative coming up, triple negative, nor am I suggesting that there may not be cases in which the payment of existing debts may not be appropriate as maintenance payment. For instance, to pay the debts of the applicant in order to enable him to continue a profit-making business or a profession may well be maintenance. So again, we see that the debt needs to be linked to the generation of income, or in the housing situation, the reduction or removal of expenses. No such case is made out here. It's not suggested that the payment of capital transfer tax will do anything to help the applicant's future maintenance. It may save him from bankruptcy. So there's an acknowledgement that by the court that it does affect his financial position and his ability to pay his debt, but there's no evidence that being bankrupt is going to prevent him from earning his living. He then goes on and deals with evidence, and continuing on about halfway through that paragraph. But in any event, apart from evidence that some 12 years ago he'd been running a betting office, there's nothing to suggest that he would be a bookmaker. The truth of the matter is he's not chosen a career. He has in the past drifted from one occupation to another. Therefore, in my judgment, he's not shown an arguable case he is making a claim for maintenance, which the court should allow, since the payment of capital transfer tax would not in any way, directly or indirectly, contribute to the cost of his future living.
It'd be a pretty odd result if a spouse could recover a success fee, but a child couldn't.
Well,
It may be an odd result, and we say that and I know you want me to get to them, that the cost regime points deal with it across the board. But nevertheless, there is a more constrained provision under the Act for anyone other than a spouse, because for spouses there is the divorce cross-check, and maintenance is there fairly and squarely. It's acknowledged by this court in Ireland to have been a deliberate legislative choice to constrain that, and Lady Hale deals in detail with the history and how that's been maintained. And in our submission, what is said here in Dennis, and we see repeated in all the other cases, is that either the debt has been created because of the ordinary living expenses, or the effect of the debt being paid is to increase income or reduce expenditure. So when we look at Jennings, that claim failed for other reasons on the facts, but it was a claim to reduce a mortgage in order to secure a future. So it failed on it not actually being necessary for the individual, but we say that is in the nature of maintenance. It's reducing an expenditure by paying off all or part of the mortgage. In Baines, if I can take you to that, it's at 525. There are we can move to apologise. There are two claimants in this instance, one of whom is making a maintenance-based claim. That's Mary. Sorry, that's Hetty, I think they're called. Page 551, paragraph 100. Since Mary's death, some expenses have been paid. These include utility bills, etc., and legal fees. Apologise, bear with me. Sorry. If we can go to 567, at the bottom of the page, does the will fail to make reasonable provision for Hetty? Hetty's claim is for, and over the page, £175,000 to discharge her debts, along with various other things. About halfway down the page, paragraph 170, it said that currently her financial position is parlous. Little 4 lines down, her liabilities, all of which are unsecured, amount to £148,000. These include bank overdrafts, some professional fees, Mr. Midgley's fees, legal fees incurred in pursuing her application for an increase in maintenance. So legal fees for another set of proceedings, etc., etc. And at the bottom of the page, 173, Hetty's legal team in the current action are now working on the basis of a conditional fee agreement which provides for a success fee. the uplift is 20%, the base costs, etc. Accordingly, her liabilities amount to some £450,000. At 177, if no award is made, she's likely to be made bankrupt. There is no evidence that bankruptcy will have an adverse effect on her future prospects as an actress, so not affecting income. And then on to page 574, paragraph 201. Most powerful factor is in her favour is her parlous financial position, but there are other counterbalances.
Sorry, which paragraph is that again?
Sorry, that was
201.
201.
201. And then over the page, it's in paragraph 203, 4 lines down. Moreover, the payment of existing debts, which was Mary's primary concern, is not maintenance for the purposes of Hetty's claim. Now, in this context, that's being used because she's making the claim on the basis she qualifies as someone who was maintained for 2 years. But it's the use of the word maintenance, again, in the same Act, and what is being said, paying existing debts isn't maintenance. She had disclaimed responsibility, etc. And then at paragraph 208, reading together, so section 11E is the qualifying as a person who's been maintained before the death.
You're at paragraph
208 at the
Thank you.
bottom of page 275. Apologise.
Thank you.
So reading together section 11E, which is the qualifying via maintenance as someone who was maintained before death, and section 12B, which is the reasonable financial provision for maintenance. The first statutory question I'm required to answer is, does the will fail to make financial provision as it would be reasonable in all the circumstances for Hetty to receive for my maintenance? The answer is no, it does not. And again, it's the court looking to see not just the debt, but whether the debt is the product of the ordinary income, recurring type cost of living, or is going to diminish income in order to meet those costs of living. Maintenance is not about capital for capital. It can be capital to redress an ordinary cost of living, such as paying off a chunk of mortgage, or it can be to address a capital need that will block income ability, such as the payment of business debts. And we have another example of that in the Espinza case, which is in the other authorities bundle at page 674, but I'm conscious of time and probably don't have time to take you to that. We haven't been able to find a single case where the court, reported case, where the court has found maintenance where it's capital for capital, where it has nothing to do with either reducing past or future expenses or increasing or stopping a block to past or future income. And we say the word maintenance means something. The courts have consistently linked it to the notion of the costs of everyday living and the caution with which in Dennis, as he then was Lord Justice Brown Wilkinson, talked about the fact that a debt could be for maintenance with the triple negative, is an indicator, a very loud indicator, that not all debts will be for maintenance. But to say, I have this debt and I need a lump sum to pay this debt is not, without more, for maintenance.
And what's your definition of a debt which is for maintenance?
My Lord, as I just indicated, looking at Mr. Justice Brown Wilkinson's wording, which has been constantly approved, it has to directly or indirectly enable the claimant in the future to discharge his costs of living. So it either has to reduce his costs of living or remove a barrier to his income or enable him to earn more.
So I thought that you were saying that some debts, by virtue of the manner in which they're created, cannot be a debt, the discharge of which is for maintenance.
Sorry, my Lord.
I thought that you were saying that some debts, by virtue of the manner in which they are created, cannot be discharged for maintenance purposes.
Well, my Lord, we would say a debt that was created that had nothing to do with everyday living. So that might have nothing to do with everyday living because it's gambling or buying Porsches or incurring fines. And we would say that would not be, unless you had a situation that Mr. Justice Brown Wilkinson contemplated but ruled out on the facts, that the consequence would be something that created a barrier to future income.
So the test is everyday living. Is that right?
Everyday living. And we say, whilst a success fee on a CFA to fund this litigation is intended to generate money that helps the defendant's future needs, the payment of the success fee is not for maintenance. The success fee is not incurred as a cost of ordinary living. It's not income or expenditure of ordinary living or a way of meeting it. And the paying of it, whilst it will increase the amount of the award, is not in just the same way as the Dennis tax and the existing debts in the Baines case.
And what do you
It's
say
not changing the income situation or the expense situation on the other side. But
and
income
what do you say
and
about
expense of
the
ordinary
proposition that everyday living or ordinary living, which are two expressions you used, sometimes involves litigating?
It may be our everyday living, but I don't think, in our submission, that Parliament or most people would understand that everyday living included litigating.
Could you just, you referred to and rightly didn't take us to a case in the supplementary authorities. Could you just give me the page reference?
The head note is, start of it is 674.
674, right. That's probably it, unless there's a particular passage in the judgment.
Bear with me 1 second. 683 from about a third of the way down the page.
Right.
the sort of centre third of the page, and there's a little bit more about it on 685.
Thank you very much.
Oh, I'm being reminded we're supposed to have a break. If that's a convenient moment.
Might be a little bit early. Yeah, we'll press on. Thank you.
So I should say, my lords, the only situations where we have been able to identify the possibility of debts that are not, as I've described, related to the income or expenses that make up the cost of living and meeting the cost of living are the costs and CFA cases that have existed in recent times, which are in the papers before you. Then if I can turn to our submissions in respect of section 58 A6.
Yes.
My lords, this court recently considered statutory interpretation in some depth in the case of, as it's commonly referred to, PACAR.
Yes.
Which I think involved my lords Leggett and Stevens, so you will be very familiar with it. My lords, in this case, we are dealing with a provision that is different in the sense that the key term entry point, costs order, is not defined. It's not defined in the statute. It's not defined as such in the CPR, and we haven't been able to find any statutory definition of it, and my learned friends do not suggest that there is one. However, we would submit that there is a similarity with PACAR in the sense that Parliament must be taken to have chosen to use a wide term in order to achieve its purpose, namely preventing or stopping the failed experiment of allowing claimants, generally claimants, to recover their success fees in any proceedings from the other party. And to that end, we pray and aid the explanatory note of the amending statute and indeed the outcome of the Jackson review that was put before Parliament. And if I can take you to those. So the provision itself is in the core bundle at page 458. And before we go to subsection 6, if I can just highlight at paragraph 50, clause 58, subsection 2, there are some provisions that describe what a CFA is. CFA, subsection A, 2A, CFA is a conditional fee agreement is an agreement with a person providing advocacy or litigation services which provide for his fees and expenses to be paid only in certain circumstances. So that's the conditionality. B, for a success fee, if it provides for the amount of any fees to which it is applied to be increased in specific circumstances. So the success fee, we all call it a success fee or an uplift, it is still characterised as a fee. It's a fee for services, but it's an enhanced, an uplifted, an increased fee. It's not some other type of receipt. And then there are various other provisions limiting the extent of the success fees, etc. And then we have 58A on page 462. This is the current iteration with the bar on recovery of success fees. But again, if I can just go past subsection 1 and 2 first, and we can see that family proceedings are explicitly excluded from the ambit of proceedings for which a success fee can be obtained. And that has always been the case. If you want, I can take you back to the original iteration, which we have in the bundle at page 451. And then when success fees were allowed, we've got that at 456. So it's always been the case, and there's a very detailed list, and Inheritance Act provisions are not included.
Could you just remind me, in relation to family proceedings, it would still be against public policy. You can't recover the costs, but it would still be against public policy, and therefore the fee arrangement would be void.
Because conditional fees, but for statute, offend against champity and maintenance, and are therefore unenforceable. And we did put, I'll have to dig it out, but we did put in certainly our written case a reference to a more recent case that makes it clear you can't then come along and recover some fees, even by way of some sort of quantum meruit, because it's unlawful, it's against public policy. So you have to have the statutory ability to enter into these agreements. So people have to enter into the agreements in a way that complies with the requirements of the statute and any regulations made under the statute. So, for instance, when there was what we would call the failed experiment, the period when success fees could be recovered from the other side, one of the requirements was that you had to serve notice on the other side that there was a CFA, because otherwise they wouldn't know and be able to take account of that in how they made their decisions about how to litigate. And if you didn't serve the notice, you couldn't recover from the other side. But to go to my Lord Stephen's point, if you're not within the statute, you can't, as a lawyer, you can't even recover from your client. And it's not a lawful contract, and you can't pursue a claim for quantum meruit in respect of your work. Parliament has consistently made a very conscious decision to exclude family proceedings, but has never... Initially, there was a very limited scope when CFAs first came in, then they were extended to all civil proceedings, and from that point, Inheritance Act claims have been claims in which there can lawfully be a CFA.
And that was in about 2000?
Yes.
With effect from, in 1999 legislation, with effect from
everyone
2000?
Then rushing around. Indeed. Then, over the page at 463, we have the provision in question. A costs order made in proceedings may not include a provision requiring the payment by one party of all or any part of a success fee payable by another party under a conditional fee agreement. And as my Lord Legate pointed out earlier, that hangs, we say, off the meaning of costs order. There is nothing in this provision that says an order made pursuant to section 51. There is nothing in this order that limits the proceedings in which the order is made, the type of proceedings, the court in which the proceedings is taking place. In our submission, costs is there as a descriptor, in the same way as you would talk about a damages order or an order for damages, possession order. The product, my lord.
Don't worry. No,
The product of a court's activity is two things, a judgment and an order. An order is the implementation. If you look in the CPR, I think it's 41, it talks about the whole thing, but we also talk about particular provisions within an order as being an order. So you could have, in terms of the whole thing, an order that would be described variously depending which bit you're talking about and which function, which implementation you're talking about, a possession order, a damages order, a costs order. That might all be in one order. The fact that you have a consent order, consent indicates how it's arrived at, but you might have a consent order that makes provision for the payment of a global sum. The fact you've wrapped up damages and costs in one provision in that order doesn't stop it being a costs order.
when you say it, what do you mean?
The order.
The whole order?
Yes.
So, I see. Right.
Well, surely you only mean the costs element in that situation. Yeah.
What we're saying is, if you have an order, you can properly describe it as a costs order if there is an element of it that deals with costs in some way.
But
whether that's
my Lord's
allowing...
point is, you, as I understand, you say that the whole order is properly described as a costs order.
Indeed.
I mean, that's not a common use of the expression
No.
costs order.
Well, my lord...
That's going a bit further than you need to, I would have thought.
Yes.
You're saying that
All I need
the
say
whole order, in that case, is a
I
costs
can
order.
call it a costs order insofar as it deals with costs.
Yeah.
I think is as far as I actually need to go.
The bit I was mumbling about was it says a costs order may not include provision.
Yes.
Supposing the only provision in the order which could be said to relate to costs relates to the success fee. Is that what you say is the costs order then?
Then the whole thing would be.
The whole thing? Even though it's
Sorry,
dealing
if
with...
you have an order and the only thing it does is deal with the success fee.
No, you've got an order dealing with all sorts of things.
Yes.
But it has nothing in it about costs except there is a provision within it for the payment of the success fee.
Indeed. Because, as we saw from section 58, subsection 2, the success fee is the same nature as the other legal fees that form part of costs. So the fact it's a success fee does not stop it being costs. It's not like saying damages and interest. They're conceptually two different things.
I mean, on my example, so you've got a paragraph, you've got an order, it's got 10 paragraphs.
Yes.
It says nothing about costs at all for reasons we may be concerned of. But paragraph 10 says the defendant shall pay the claimant success fee.
Yes.
Now that surely can't be permitted, can it, under this
No, it's
section?
not permitted because the order contains a provision which provides for a success fee. The fact that a success fee is costs and the order contains something that deals with costs means you can describe it as a costs order. It doesn't cease to be a costs order because it has multiple provisions and the rest all deal with other things.
I mean, the mystery here is why the section doesn't say an order made in proceedings may not include. Why does it say a costs order? That's to my mind the oddity about this provision.
I would have to accept that, but the option is either that it is talking about something, it is confined to orders that only deal with costs, or it is confined to orders that explicitly refer to costs.
And that would include a success fee, an order that provided for a success fee.
Yes.
I mean, is there another way of...
I think our submission is it's a wide term, and what it indicates is something about the order, namely that within it, it makes some provisions, some dealing in relation to costs.
Is there another way? I mean, in asking oneself, why does it refer to a costs order rather than just an order? One slightly look at it from a different angle and look back at the provision that was included in the 1999 Act. What you have here in section 58 and 58A is a regime that for the first time legalizes success fees and conditional fee agreements. I mean, they were unlawful before, unenforceable.
Indeed.
So what it does is, what the regime does is to make lawful conditional fee agreements, provided certain conditions are satisfied and provided they don't relate to criminal and family proceedings and so on. And they also include, as from 1999, a means by which the success fee can be recovered from the other side. And the mechanism that is provided in 1999 is the mechanism of a costs order. That is the means provided whereby a successful party can recover the success fee. What happens when in 2010 or whenever it is that route is removed.
Indeed.
And maybe that's why it refers to a costs order. It removes the one route by which, under the conditional fee agreement regime, the success fee could be recovered from the other side. And that's why subsection 6 is talking about a costs order, because it's removed the previously available route for recovery of a success fee.
My Lord, undoubtedly, when you look at the two, there is some similarity in the language, and the ability element is being removed. My Lords, in our submission, the same points would apply. There is no reason, and it's on page 456, the provision that allowed the requirement to pay any fees under CFA which were a success fee. There is no reason why an order that had lots of provisions, an order that had a global sum.
But in a way, one doesn't perhaps at this stage need to bother too much about what is meant by a costs order, because this provision on page 456 provided the route, and the only route provided by statute, for recovery of the success fee. And then that route is removed, and it's removed by reversing subsection 6.
Yes.
So it's removed the only route.
If we go back one step as to where it started, just to, as it were, complete the journey, albeit in reverse. On page 451, we have the original section 58 enabling. And on page 452 at subsection 8 then, where a party to any proceedings has entered a conditional fee and a costs order is made in his favour, the costs payable to him shall not include any element which takes account of a percentage increase payable under the agreement.
Which part of page 452, sorry?
Sorry, it's 452 subsection 8.
Thank you.
So this is the first time that the statute is allowing CFAs, but only the recovery from the beginning. Everyone was very clear about that, of the base fee. And the similar language, it's not as similar as the last two we've looked at, is used, but the notion of a costs order, an order dealing with costs, we would say, cannot.
But all this reinforces what you would have thought naturally as the reading is that a costs order means an order dealing with costs as costs. There's a stage in proceedings at which costs are dealt with. There are various contexts in which, for example, costs can be recovered as damages.
My lords.
And it wouldn't, on the face, I wouldn't have thought it was a very natural reading of a costs order to say that encompasses an award of damages, which includes, for some reason, an element of litigation costs.
My lords,
in those contexts where they're recoverable.
I'm not aware of any instances where a success fee has been recovered and the court, or a court has been persuaded to make an order for the recovery of that, which is costs, by characterising it as another sort of relief.
Well, one context is if you've incurred costs in litigation with a third party. Sometimes you can recover those as damages from somebody who's promised to indemnify you or something like, or against whom you have a claim. And that you wouldn't think of as a costs order.
Because a costs order is dealing with the costs as between the parties to the proceedings.
Indeed.
Yes.
But of course that's what this is.
This is. As opposed to a loss I have suffered.
Well, that
the loss being
normally you can't recover costs of proceedings as damages from the other party to the proceedings. That's a rule. And,
so they're not your costs of the proceedings, and the success fee is costs of the proceedings. And so
that seems to be a point against you, because in a it just means that it's dealing with costs as costs.
Well, my lord, it doesn't say under section 51. It doesn't say pursuant to the court's power to award costs of proceedings. It simply says a costs order. It could very easily have said in any of the iterations, allowing, disallowing, the power, the cause of action, or use something that was another indicator as to what the nature of the order was.
I mean, the underlying policy of 8 is that success fees are not going to be recoverable.
Indeed.
And the assumption is that their costs and could only be treated as part of a costs order. That they would be dealt with as part of the costs of the proceedings.
My lord, the explanatory note, I've just managed to misplace my page reference for that, which I will find. It's towards the back of the core bundle, I think. 1095. Starts on page 1095 and over the page 196, paragraph, section 44 deals with conditional fee success fees. So this is the explanatory note to LASPO, which brought in section 58A6. And at 287 at the 282 at the bottom of the page says the effect of the amendments is that the success fee under a CFA will no longer be recovered from a losing party in any proceedings. The lawyer will still be able to recover a success fee from a client under a CFA.
Sorry, which paragraph are you on?
It's 282 at the bottom
Thank you very
of
much.
page 1096.
Well,
I'm being
just
reminded
to
of
take Lord Legg's example of either suing for an indemnity in relation to costs, or another example, if one had paid all the costs, including the success fee, to a solicitor, then found that there had been negligence and you wanted to recover the fees that you paid incorrectly, would that be a cost order when you got damages from the solicitor, including the success fee?
No, my lord, because it's not a order dealing with the costs that have been incurred as costs of the proceedings between those parties. So,
Well, that's coming perilously close to accepting that an order for maintenance isn't an order made for costs of proceedings as between those parties, even if part of the calculation takes account of that liability.
sorry, my lord, I didn't quite follow that.
Well,
My fault.
Well, I'm just suggesting that your answer to Lord Stephen's example makes it hard for you to distinguish this case.
well, I suppose the difference is in this case we're talking about the parties to the proceedings.
Indeed.
Whereas my Lord Stephen's example is not as between the parties to the proceedings.
Claiming a loss from a third party where your loss constituted
Right, yes,
costs
I see.
in other proceedings. But you could not describe that within the context of the claim that is being made to recover it as costs of the proceedings. I'm conscious that we were supposed to have a break. Is now
I'm reminded. I'm grateful. We'll take a 10-minute break at this point.
My lords, I'm conscious I have slightly less than 20 minutes left.
Yes.
Just to finish off that point, when one looks at the various sections and the iterations and where we have ended up, it talks about an order in proceedings and refers to by one party against another party. And, my lords, we would submit that that makes it very clear it's talking about the costs of the proceedings that the order is made in between those parties, not the damages, indemnity type situation. I didn't give you the reference to PACAR. We rely on paragraph 40, which summarises in the judgments of, I think it's Lord Sales, at page 899 of the core bundle. And, my lords, if I can just very quickly say, as I indicated, we pray and aid the explanatory note. There is also, you've seen in the written cases, and you have the various reports from Jackson, which make it quite clear the ending point was all proceedings, but perhaps more importantly, for the purposes of this exercise. In the supplemental bundle, we have the government's response, and insofar as it deals with CFAs, it's on page 1469.
Sorry, this is the supplementary bundle.
Supplementary authorities bundle, 1469.
Thank you.
Reforming civil litigation funding and costs in England and Wales, way forward, and it's under paragraph 5. The government intends to abolish the general recoverability of CFA success fees from the losing party. In the future, any CFA success fee will be paid by the CFA funded party rather than the other side. Crucially, this would give individual CFA claimants a financial interest in controlling the costs incurred on their behalf. It returns the position to when CFAs were first allowed in civil litigation in England and Wales in 1990s.
Yes.
My Lords, then perhaps if I can move on to where my Lord Legate wanted me to be, in terms of the incompatibility with the CPR and the exercise of discretion in relation to costs that arises under section 151 of the Supreme Courts Act. And perhaps if we can quickly start there, which is in the core bundle at page 501.
What's happened here?
We have these provisions which we're all very familiar with, but they do bear going back to and looking at. Subsection 2 makes it clear across the vast majority of courts, the costs of and incidental to any proceedings. So again, it's the costs of proceedings shall be in the discretion of the court. Subsection 2 provides, subject to any power, to make rules of the court. Such rules may make provision for regulating matters relating to the costs of those proceedings, including, in particular, prescribing scales of costs to be paid to legal or other representatives. So this is very clear that there is a discretion across costs of proceedings with the court dealing with those proceedings, that the rules will regulate anything done in relation to costs. And to reinforce the point, subsection 3 says the court shall have full power to determine by whom and what extent the costs are to be paid. And, my Lords, we say that that power is not one that can be ousted and ignored, even if the court has another power to deal with the costs of the proceedings between the parties to the proceedings. When we look at the regulations that are made as provided for, so if we can start on page 444. CPR 57, which is absolutely crystal clear that the civil procedure rules apply to Inheritance Act claims, including those in its sub-rule 2 in the family division, with limited exceptions that aren't relevant here. Then if we go to 405, we have CPR 44, sub-rule 1, and 44, of course, is the general rules in relation to costs.
Sorry, page?
Sorry, 405.
Thank you.
44.1 includes some definitions, and just for completeness, costs includes fees, charges, etc. So we would say the success fee, which is a fee, an enhanced element, but a fee, quite clearly under the Act, is squarely within costs for the purposes of the CPR. Then if we can go to 407. We have CPR 44.2 says that the court has a discretion whether costs are payable by one party to another, the amount and when. If the court decides to make an order about costs, my lords, we would say that means any order dealing with something that falls in the description of costs. The general rule is the unsuccessful party will be ordered to pay. The court may make a different order. The exceptions to the general rule don't apply here. That's in sub-rule 3. Sub-rule 4, in deciding what order, if any, to make, the court will have regard to all the circumstances, including conduct, success, part, etc., and C, any admissible offer to settle made by a party which is drawn to the court's attention and which is not an offer to which the cost consequences of Part 36 apply. So, in order to deal with costs, in order to make an order about costs, the court has to act properly and judicially and, having the discretion, have regard to that which it is required to have regard to. And then, so far as CFAs are concerned, we have in the bundle at page 395, 3617. It says this rule applies whereupon judgment being entered, a claimant fails to obtain a judgment more advantageous than a defendant's Part 36 offer, and B flips it over the other way. And sub-rule 3 provides that in the case of a claimant failing to beat an offer, paragraph if 1A applies, the court must, unless it considers unjust to do so, order the defendant is entitled to costs including any irrecoverable pre-action costs from the date and interest. So there are, as we all know, fixed consequences in relation to the Part 36 regime that a court must impose unless it considers it unjust to do so, and so has to go through a process of knowing what offers there are and considering whether there are offers beaten or not, and whether it should step behind that. If I can then take you to the Lilliman decisions. So the first one starts on page 770 in the bundle.
Say 717 or 78?
770.
770, thank you.
It is an Inheritance Act claim by a surviving spouse, so it's a spousal claim. And if I can just take you to page 788, paragraph 71. Having gone through the financial position in relation to the estate, it says the above summary ignores the parties' agreements about 4 legacies. It also ignores the contingent liability for costs in these proceedings, which I'm unable to either quantify or guess as to their likely incidence as between the estate and Mrs. Lilliman. Counsel were united in submitting that I had no alternative but to leave the contingent cost liabilities entirely out of account, however unrealistic in the real world that might prove to be. And we then have at 794, the second decision, which was dealing with costs, there having been in that case Part 36 offer, where we can see from the head note that there was a failure to obtain a judgment more advantageous, and therefore the consequences described by Lord Justice Briggs, as he then was, as the no-holds-barred approach. He then, if we go to page 801, at paragraph 25, he makes his decision about what to do in light of the Part 36 offer, and he does in fact modify the consequences under 36(17). But at paragraphs 26 and 27, he comments about the position he found himself in. He says, "I must, in concluding, express real sense of unease at the remarkable disparity between the cost regimes enforced, on the one hand for Inheritance Act cases, whether in Chancery or Family Division, and on the other hand financial relief proceedings." And he then describes what he understands the differences to be, namely that in family proceedings there's a presumption against cost shifting, and the court is able to look at costs when it's looking at financial provision, my lords, and that is in the context of a requirement there that all offers are open, there being no application of the cost regime under the CPR and no Part 36. It says, to the substance of both types of proceedings, yet at their root, at least where the claimant is a surviving spouse under the Inheritance Act, are directed towards the same fundamental goal, albeit the relevant considerations are different. My lords, we would say that's an acknowledgement of some of the points we were making earlier about the tests. And that there is an important difference that one of the spouses has died, so his estate stands in his or her shoes. I express no view on which of those fundamental divergent approaches to costs is better calculated to serve the ends of justice, in particular to promote compromise. I merely observe that the potential for undisclosed negotiations to undermine a judge's attempt under the Inheritance Act to make appropriate provision for the surviving spouse is possible disadvantage of the civil litigation cost regime currently applied to such cases by comparison with the regime applicable in the financial provision divorce. And we say that is the position. There has been an explicit decision to treat all Inheritance Acts proceedings as coming under the CPR, and it is clear from section 51 and the provisions of the CPR, that some of which I took your lordships to, that those apply in relation to fees as part of legal costs within proceedings as between the parties, and that in order for the court to make an order dealing with something rightly characterised as costs, which a success fee is, the court has to go through the process of having regard to the things that the CPR, generally under 44, and if there are Part 36 offers, require the court to consider before making an order. And the fact, if you're against us on whether an order could be part of an award otherwise, under the powers of Section 2 of the Inheritance Act, they nevertheless do not cease to be costs of the proceedings, an order that one party pays over a sum that reflects those costs of the proceedings still has to be approached through the process required by the CPR. And that cannot happen at trial. It can only happen after the event, when the offers that, unlike family proceedings under Part 44 or Part 36, can be made available to the court. And it's interesting that Mr. Justice Cohen, in his judgment, it's at page 217, paragraph 48. So the parties have not been able to agree I should know any Part 36 offers. So I will need to deal with costs between the parties separately. He's talking there about the base costs. We would submit there can be no distinction. He accepts, as reluctantly Lord Briggs did when he was dealing with the Lillerman matter, that you cannot ignore that which Section 51 and the rules made pursuant to it in the CPR require you to deal with before making an order that deals with costs. I'm conscious of time and that I should give way.
Thank you, Ms. Stevens-Hoare. Ms. MacDonald.
My Lords, our submissions will address 4 key topics. First of all, conditional fee agreements and the Jackson reforms. Secondly, the funding of 75 Act claims and access to justice. Thirdly, we will focus on the question of what is a costs order, and in that context we'll consider the operation of the civil cost regime in these kinds of claims, and that will include references to Part 36 and some submissions in relation to base cost treatment. The fourth element will be the analogy with certain family proceedings and why that analogy matters, and that will be the focus of the submissions of my learned friend Mr. Wagstaff, KC. The family law analogy is referred to in our written case at paragraphs 3.5 to 3.9, page references to that. I'm not sure my page references are going to be very useful to your lordships because they're in the core bundle and it's duplicated in the key documents. So if it's convenient, I'll just refer to paragraph.
Yes, please.
It also matters because of the treatment of debts in the context of matrimonial finance, which is expressly referred to in this appeal in grounds 3 and 4 of the grounds of appeal, and of course even more explicitly the appropriateness of the analogy is the focus of ground 5 of the appeal. So that is why we are dealing with it. In terms of timing, my lords, I will plan to finish my part of the submissions at 3 and Mr. Wagstaff, KC, after the short break, will then complete our submissions.
Yes.
My Lords, by way of introduction, I'd just like to make a few general points before we get to the Jackson reforms. First of all, the virtue of this Act, the 1975 Act, is the breadth of the factors in it which the court can take into account and which, using Mr. Justice Briggs' words in Lillyman, page reference 780 in the core bundle, may be of infinitely variable weight. What that structure enables the court to do in any given case is tailor-make the relief to the particular claimant. And that necessarily creates, in many cases, a fairly wide range of potential outcomes, as was acknowledged by Baroness Hale in this court in ILOT, and page reference to that is page 768 of the core bundle at paragraph 65. But it's that variability and that range of outcomes which results in almost every claim which is issued under this Act to settle. Almost every claim settles. Some settle, obviously, before a claim is issued, some settle at the door of the court. There's no published statistics I'm aware of on how many, but certainly from our experience as practitioners in this field and a straw poll of professional clients suggests that over 95% of these cases settle. Now, sometimes it can actually be quite advantageous to settle these claims or a dispute about an estate by doing so under the Act, because amongst other things, the court has got the power under the Act, of course, assuming that the criteria are met otherwise, to restructure the disposition of an estate. And that can have very helpful tax consequences, which in fact can put money into the pot of the estate for the purposes of creating reasonable financial provision or enhancing the provision that can be made.
Well, we see what happens if you don't settle in this case, when you've got a success fee potentially payable. You end up being possibly forced out of your care home by the time the costs have accumulated of the litigation.
Well, my lord, on the facts of this case, we don't actually have any knowledge about how the care home fees are being funded.
No, but we know that by now a huge amount of costs have been incurred, which must exceed the size of the estate, I would have thought, if you include success fees on them.
Well, the success fees will be a relatively small part of that, the 16,750.
Well, perhaps my point's partly about proportionality.
But, my lord, it's absolutely correct that in many of these cases the cost will become a very large sum. In some cases, they will indeed match the amount of the estate. But these claims are prime candidates for dispute resolution. They're prime candidates for mediation, not least because they often involve grieving families, and far better for them to sort out their affairs privately. But many settlement agreements of these kinds of claims will require a court order to be made to implement them, either because one needs to be made under the Act so as to quite lawfully realise the tax advantages that exist, but also, of course, because many of these cases involve children and protected parties, and the court's consent under or approval under Part 21 is required. They may be settled by way of a straightforward consent order. They may well be settled by way of a Tomlin order. And one point which I will come on to later is the question of to what extent, to use the appellant's arguments, a costs order can actually capture a Tomlin order if the terms of settlement which are referred to in the Tomlin order include, by consent, the payment of a success fee. I will come back to that point. But as a matter of reality, many of these claims do settle by way of a Tomlin order. Another important contextual point to make by way of introduction is that most of these claims are effectively tripartite. In many cases, the personal representative, PR, will be a neutral, independent party to the claim. They obviously have to be joined because the relief that is awarded under the Act is primarily awarded against the estate, is entirely awarded against the estate, subject to any consequential orders that have to be made to bring money back into the estate. But it is the estate against which the award is made, and it is the estate which has to pay the award or otherwise transfer assets, etc., depending on what kind of relief is granted. In terms of the CPR cost liability, that will normally, the losing party will normally not be the neutral personal representative. It will be the beneficiary who's been joined to the proceedings who fights the case. I don't want to be too generalistic. There are, of course, cases where it's the same person. There are very occasionally cases where personal representatives, even though they are not beneficiaries, will take on the active job of defending the case because, any number of reasons, there might be a wholly discretionary will trust, and it may be more appropriate for the PR to do it. But I'm just explaining that by way of context. The point is that often the losing party for the purposes of a cost liability will in fact not be the party who has the duty of funding the award. And that is one key difference to the kinds of standard civil claims which are the focus of the Jackson reforms. There will indeed also sometimes be cases, and the very recent case of Barla, page reference 1047 in the supplemental bundle, is one where there will be competing claims heard at the same time. In that case, there was a widow, 2 minor children, and an adult sister who was a protected party. So the courts, obviously it makes sense to deal with all the claims at the same time, but in terms of costs, there may be a slightly unusual outcome in cases of that kind, because the claimants are defending each other's claims. The different forms of relief which the court may provide in 75 Act claims are prescribed. My learned friend took you to section 2.1, but I'd ask you briefly to turn up that section again. The page reference is 469 in the core bundle. So this is an exhaustive list of the kinds of orders the court can make in these claims. And you've got A through to G. A and B are the only ones which are monetary. You can have periodical payments or you can have a lump sum. All of the others are non-monetary forms of relief. Transfer of property, a settlement for the benefit of the claimant, acquisition out of property contained in the estate. I mean, an example of that would be an option to purchase a house, which was the result in Lewis and Warner not very long ago. A variation of a nuptial settlement, a variation for the claimant's benefit of existing trusts within either the will or intestacy. And the same applying to any settlement made during a civil partnership. But it's important then, before departing from section 2, to look at little 4 on page 470, subsection 4, because the court, in making a section 2 order, may also provide within its order such consequential and supplemental provisions as it thinks necessary or expedient for the purpose of giving effect to the order, or for the purpose of securing that it operates fairly as between one beneficiary and another. And then you've got some particulars of that, including at little c, very broad power to give the trustees of any property which is the subject of an order such powers as appear to the court to be necessary or expedient. So that is an important supplemental provision to the general forms of, to the prescribed forms of relief, because it gives the court power not only to make sure that it's doing the right thing in terms of restructuring an estate, but as in the context of this case, and Mr. Wagstaff will develop this in relation to matrimonial cases, it gives the court power to add in what is needed to make sure that any probable or possible events are covered. Now, in the context of a CFA success fee, that may be the question of whether or not it actually is triggered. The court may make an order that is contingent upon that. In the context of a known binary uncertainty about what is in the estate because of, let's say, an outstanding BPR claim in the revenue. The court might well wish to make an order in the 75 Act claim, but ensure that there is scope within it for different operation depending on what ends up being within the net estate. And there are many variations upon that. So, my lords, by way of introduction, that is the framework within which we are operating. And these claims operate in the real world. Judges in these cases, up and down the country, because many of them are litigated in county courts, have to use their own knowledge of society and values, and I will come back to that point, in order to assess each of the criteria in the case, and importantly, to decide what relief or what package of relief to grant under Section 2.1. Now, I'd like to just then come on to our first key topic, which is CFAs and the Jackson reforms. And I'm dealing here with purely with CFAs which have a success fee as a percentage of the base costs. There are, of course, other kinds of CFA, including discounted CFAs, but we're only talking here about those which have a success fee as a percentage of base costs. And the reference, I don't think I need to turn it up, to that is, I think my learned friend just showed you at page 458 of the court bundle. It's at section 58(2)(b) of the 1990 Act. Now, may I ask you at this point, please, to take up our written case at paragraph 216 and 17. Where we deal specifically within the Jackson reforms with what the counterbalancing measures which Sir Rupert Jackson recommended in his final report. And for reasons which I will develop in a moment, in fact, we think that the word arguably, which you have 3 lines up from the bottom of paragraph 216, should in fact be deleted for the reasons I'm about to explain. In fact, the acceptance of Sir Rupert Jackson's proposals about the counterbalancing measures, particularly the 10% of general damages going up, did constitute an acknowledgement that awards of damages should be increased to take into account success fee irrecoverability by way of a cost order. And the key point, which I will develop now, is that far from Section 58A being a concrete obstacle, as the appellant says, to substantive relief being granted if that relief is referable to a success fee, within the Jackson reforms themselves, there was a proposal for relief to be granted in the form of this 10% increase in general damages, which was referable to a success fee. And we see that at page 1469. I'm going to need to ask you to take up the supplemental bundle, please.
But the whole point is you couldn't get it any other way. You couldn't claim it as increasing your damages.
No. I'm about to show you exactly where it originates, but that's exactly the point, my lord, that of course, a key aspect of these reforms, you can't get it by way of a cost order, but at the same time, a recognition that in many claims for general damages, a claimant might have a success fee to pay, which would eat into the damages,
Well, they might, but unless some other extraneous measure like this has been enacted, there's nothing you can do about it. You can't get, enter through the back door when you've been shut out the front.
Well, my lord, what you describe as the back door already existed
Yes,
at the time.
it did, and I don't think you could have got your success fee or anyone would have tried it under the old regime, would they?
Well, that's an interesting question because it is certainly the case that in several cases one sees a reference to the existence of a success fee. My learned friend took you to Baines and Hedger as an example of one, as being an item of financial need, a debt. And so as a fact-finding exercise, certainly there are examples of judges knowing what base costs are and what a success fee was being calculated at. It's absolutely right to say that we're not aware of a case where a success fee has been awarded as part of the relief. Absolutely right. And we certainly can't say whether it was dealt with by way of settlement because most of these cases don't go to trial. We don't know.
Doesn't matter whether it was or not.
Doesn't matter. But it is since the ability to recover your success fee through a costs order was removed, simultaneously with the cuts in legal aid, which meant that a 75 Act claimant couldn't get legal aid, and they happened on the same day. There have been claimants who've had to fund their claims by other means. Some have managed to get Section 5 relief. Some have managed to enter into CFAs with their lawyers. We are not aware of a case other than the ones which are referred to in the written cases, Clark, I think, being the first one, where there has actually been an argument about whether success fees could be recovered within an award. And that may be simply because there wasn't one which went to trial between 2013 and 2019 when Clark was decided. It would seem very odd if there had been a case during that period when a claimant did have that liability for a success fee, knew they couldn't get it through a costs order, and didn't try and get it as part of the award, because back in the real world of these disputes, as we will see later, in the context of these claims, the liability for its success fee may inhibit a claimant's ability to put food on the table or to pay for any number of pressing expense needs that they have. So,
but taking your comparison with personal injury claims, why can't a personal injury claimant say, you ran me down negligently, and that has caused me a lot of expense, and those expenses include a success fee I've had to pay to my lawyers, and the court has declined to award it as costs. Perhaps, I don't know, or it's cut it down because it thought it was excessive or something, but it's a cost I've had to incur, so why I can get it as damages.
Well,
and that has would never be accepted. And it seems to me at the moment that this case is a parallel with that.
My Lord, I'm happy to accept that in terms of specific special damages. My point relates to general damages, and I'd just like to show you exactly how it was dealt with, both within Jackson and in the Court of Appeal decision which implemented it, which does draw an absolutely straight link between that increase in general damages and the ability to fund a success fee.
That was an increase in general damages for all times, is that right?
For any type, yes, it eventually ended up being an increase by 10% in any form of general damages by reference, whether it was a tortious claim or indeed a contract claim.
At the moment, it seems to me this is a point against you, though, because it shows what was necessary to do in order to provide some kind of counterbalance, without which there wouldn't have been another way of dealing with it. And there's no parallel provision in this case saying you could increase the award under the 75 Act by 10% or something, because we're taking account of the fact that success fees aren't available. It seems to me to point to the problem of your argument.
Well, my lord, I will come back
All right.
and answer that. Can I show you what I need to show you first? And then I will certainly make sure that I come back to that question. The first, if I could ask you then to turn up page 1469.
Yes, this is in the supplemental bundle.
Indeed.
The way forward.
Right.
I'm so sorry.
The way forward.
Yes. You've just looked at it. My learned friend took you to some of this, but if the three bullet-pointed intentions of the government, the third one was to introduce the package of associated measures set out by Lord Justice Jackson. And one of those, as identified at paragraph 7 on the same page, was the increase of 10% in non-pecuniary general damages, such as pain, suffering, loss of immunity in tort cases for all claimants. So that was the proposal as part of a package. In the same bundle, whilst your lordships...
Hardly surprising it was supported by most insurers, given that the Law Commission had recommended a 50% to 100% uplift in 1998.
Yes. Thank you. Can I ask you to turn then to page 1396 in that same bundle? This is within the final report, the final Jackson report. And this is where the recommendation comes from. It starts off, the introductory paragraph in this section at 5.1 is the question of whether any measures, and if so, what measures ought to be taken to assist claimants to meet the success fees which they will have to pay in successful cases out of damages or other sums recovered. And then the proposals in answer to that question are set out. There is two subheadings, personal injury litigation and other litigation brought by individuals. In relation to personal injury, at 5.3, in order to assist personal injury claimants in meeting the success fees out of damages, he recommends, first one, that there's the 10% increase in general damages. Secondly, that the success fee for lawyers is capped at 25% of the damages. And thirdly, that there should be an additional reward under Part 36. I will come back to that. That ended up being introduced into Part 36.
He refers at the top of page 1397. On the other hand, the level of general damages in England and Wales is not high at the moment. Which
I'm going
to the obvious.
I'm going to show you the Court of Appeal case where they explain how that's dealt with.
Yes.
That's coming up very shortly.
Right. Sorry.
But what he didn't say was there won't be a problem with the fact that you won't be able to recover success fees in litigation because it'll be part of the loss you've suffered still as a result of the defendant's negligence, and so you'll be able to get it as part of your damages.
For these, yes, I mean, that is the effect of what she's doing.
Well, he's saying you can't do that. I mean, he's assuming you can't do that. On normal principles, the loss you've suffered from the negligence has included costs of having to pay your lawyers, success fee. Why not get it as damages if you can't get it as costs? Because the legislation only refers to a costs order. It doesn't say anything about an award of damages, which includes that element of your loss.
Well, Lord, I don't disagree with that within the context of those sorts of claims.
Well,
at the heart of our...
At some point this afternoon, it would be very helpful if you could explain the distinction between why you can't recover costs as damages in a personal injury claim, but why you can recover them as reasonable financial provision in a 1975 Act claim.
Absolutely. I mean, that is one of our key points, and I certainly
seems to be at the moment it goes to the heart of the issue.
My Lord, I absolutely accept it's a key point, but this is an important piece of our submissions.
Can I just point out somewhat similarly, I'm not sure entirely where you're going with this submission, and I know we've got to wait patiently until you get there, but it looks as if you're indicating that what the Court of Appeal has done in our case is, in a sense, a parallel needed in order to meet the inability to get the success fee. In other words, that the Court of Appeal has appreciated that otherwise one is going to be cutting into the award that would be given in a way that the legislature recognised in relation to general damages. But I think, much like Lord Leggett, I'm not sure how that's going to help you, because the fact is that was a piece of legislation that was finely tuned to the particular issues. We haven't got a piece of legislation like that, and it's not clear to me that one can, in a sense, say, well, the Court of Appeal is all justified because it fills a sort of lacuna in the legislation.
My Lord, the 10% increase in general damages was not achieved by legislation. It was achieved, as it had to be at common law, by the Court of Appeal in Sims and Castle, because it was the Court of Appeal who had the job of modifying general damages. And I know I keep promising things I'm not delivering, but I will come
you
to
haven't
this.
been given a chance.
I will come to this when I show you Sims and Castle, which will have to now be after the shorter journey.
We'll give you the opportunity to do that at 2 o'clock then.
Thank you very much.
Mr. McDonald, thank you very much. We now adjourn 2 o'clock, please.